In just a few days here, I'm going to be packing up the studio and heading off to Delphi, Indiana, where I'm going to be for the next 6 weeks watching the trial in the case of State versus Richard Allen. I haven't talked about this case on my channel, so if this one is new to you, I wanted to make this video to explain to you a little bit of the background of the case and why I found it so important to take 6 weeks out of my life and go halfway across the country to make sure that I have eyes on what happens in that courtroom. Mr. Allen is on trial for the murders of Liberty German and Abigail Williams, two 8th grade girls who went missing after they failed to return from a hike in a trail system in rural central northern Indiana on February 13th of 2017. When they didn't meet up with their ride that afternoon, they were reported missing, a search party was organized, and ultimately their bodies were found nearby the following day. Both girls had been killed by a knife wound to the throat. There was no evidence of any type of sexual assault, although one of the girls was apparently found naked. The other was clothed, but she was wearing some of the clothing belonging to the other girl. So some indication that both had been unclothed at some point in time. Don't know if that was before or after they were killed. Their bodies were arranged in particular postures, and tree limbs, branches had been cut at the scene and arranged on their bodies in certain patterns, certain configurations. This was a pretty horrifying crime. This is a quiet rural community. These are particularly vulnerable victims. And so this caught a lot of public attention. And the case went unsolved for approximately 5 years until Mr. Allen was ultimately arrested and charged. So this is a case that a lot of people are motivated to follow, to find justice for these two young girls, to get the truth about what happened to them and why, and to make sure that the people or person who did it is held to account. But there are problems with this case that significantly call into question whether this prosecution is going to achieve that. And so there's 3 main reasons why this case caught my attention and is something that I want to follow through to see how the trial process unfolds. Number 1, the case has been shrouded in secrecy from the moment that it was filed. Number 2, it has been marked by an extreme hostility to the defense, far more than the routine pro-state bias that I personally have kind of become accustomed to from criminal court judges. And number 3, because from my knowledge of what's happened in the pretrial process and the evidence, both that has been presented and is going to be excluded, raises significant doubts as to whether they have the right guy. From the moment this case landed in the courtroom, there's been an effort to shield it from public inspection, which is extremely alarming to me because no prosecution should require the cover of darkness. When Mr. Allen was first arrested, the probable cause affidavit that supports the charging decision provides the basic outline of what the state alleges it can prove to show that Mr. Allen committed the crime. That probable cause affidavit was filed under seal. This is extraordinary. These are, without a doubt, public documents. And so the decision to seal it precipitated a challenge by numerous media outlets and the defense themselves to unseal it and to make that information available to the public. That was ultimately successful, but it took about a month after Mr. Allen was arrested before the public was able to see what the reason was for that. A gag order was issued in the case shortly after it was brought into court as well. As we mentioned, in the investigative process, the state had no concerns about selectively sharing information about the perpetrator, about the crime, about the circumstances with the public in order to try to benefit from that, to try to use that information to help their investigation. But when it came to Mr. Allen then being able to respond to the charges that had been made against him, the state didn't want him to be able to do that like they had. So they pursued a gag order in the case right off the bat. But before a hearing could be held on it, while the motion was still pending, Mr. Allen's public defenders, he's got two court-appointed public defenders, issued a press release on his behalf. And in that press release, they asserted that Mr. Allen was innocent of the charge, that law enforcement only knew who he was because he had voluntarily approached them back in 2017, in the days following the murders, to tell them he had been on the trails that day during this time frame, gave them information about where he had parked, where he had walked, who he had seen, what he was wearing, so on and so forth, consistent with what one would probably expect from any good Samaritan who had been out in the area and wanted to assist police with their investigation. The press release contended that Mr. Allen had no criminal history. He worked at CVS, had a wife and family, apparently lived a quiet life in this quiet part of Indiana up until this point in time. And the defense attributed the charging decision to politics. Apparently there had been a contested sheriff selection just leading up to this timeline of the arrest. There was also a federal lawsuit that had been filed by a former deputy sheriff who had sought to pursue certain investigative leads in these murders and was not allowed to do so by the incumbent sheriff. So the defense argument was essentially the incumbent sheriff was under pressure to show some type of action in the case, to solve the case, in order to assist his re-election efforts, leading to this arrest of Mr. Allen. Well, that didn't fly very well. Although, certainly there was no order prohibiting the statement at the time that it was given. The state and the court, by all appearances, really didn't like that they had done that. So a gag order was ultimately issued in the case. And as a result, then we are in the situation where what we know about the case is now what we are able to glean from the court filings, from the representations of the parties, and the evidence that they submit in support of various requests for relief. Throughout the course of this case, however, a number of those documents were also kept off of the public docket. There have been a whole series of pretrial processes that I'm not going to detail in depth here because there is just a lot. There is a lot that has gone on in this case since it was first filed. But for purposes of explaining some of the secrecy here that concerns me, I'll just point out that at one point the case was taken up to the Supreme Court of Indiana on an extraordinary writ petition against the judge in the case. I'll talk a little bit more in detail about this in a minute. But during the course of that Supreme Court process, one of the issues that was raised is that matters were being kept off of the public docket. Filings that should be there, should be publicly available, should be reported so that we know that they exist, were being kept off. So ultimately they were restored, and Judge Francis Gold, the judge on the case, who we are going to be hearing quite a bit about in the next 6 weeks, Judge Gold blamed the clerk, said basically it was the clerk's fault, and ultimately that had to be fixed, but again, took the matter landing in the Indiana Supreme Court for that to apparently catch anybody's attention and get corrected. The last real indicator of the hostility to the public interest, the desire to close off this process, is the exclusion of cameras from the courtroom and the refusal to provide audio recordings of the hearings that are made for purposes of creating an appellate record, refusal to release those to the public. There's one notable exception that I'll also talk about in a second here. And so what that means is that there is no direct source information that the public is going to be able to go to know what happened in this trial. We're going to be stuck with the observations of whoever is able to be there and be in the courtroom and see what's happening and report what's happening. So there is a very high need for accuracy and for just people who understand what it is they're watching, the significance of the process, the rulings, the arguments, and so forth, to be in that courtroom, since we won't have the opportunity to live stream it, give our commentary on it as it unfolds. The information is, it's going to be very limited what we're able to get. So that's where I come in, and the reason why I thought it was so important to be in this particular courtroom. The second reason I thought it was very important for me to follow this case is because the hostility to the defense has gone far beyond what I consider to be kind of normal and routine. And so I want to go ahead and give you some examples of what's happened in the case that really illustrates that in my mind. So first off, when Mr. Allen was first arrested, the state contended that the local county jail, Carroll County Jail, wasn't able to keep him safe if he were to be housed there. Now, normally, somebody gets charged with a crime in a state court, you can be held without bail, or if you're unable to meet bail, in the local jail while you're waiting for trial. That's fairly normal, especially for people who lack resources to post large amounts of bail and so forth. But the jail in this case said they couldn't guarantee Mr. Allen would be safe in their jail. So instead, he was held in a state prison. And not only was he held in a state prison, he was held in the isolation unit of a state prison. So Mr. Allen, with no criminal history of any kind, goes from going about his day-to-day life, going to his job at CVS, normal, routine, everyday things, to suddenly being held in isolation, surrounded by some of the state's most dangerous criminals, in the area of the prison where the people who are most violent, most unpredictable, most defiant are being held. This is a punitive unit. But in Mr. Allen's case, according to the state, this was necessary to be able to keep him safe. Well, if you know much about isolation units, this is something that you've ever looked into. They are extremely psychologically damaging. There's very good evidence that extended isolation will drive any human being crazy. We are social beings. We're programmed biologically to need to be around others, to have contact from others. And so taking that away, putting somebody in an environment where their movement is restricted, their contacts are restricted, and they have very little in the way of entertainment, anything to occupy your mind. Maybe, I don't know, maybe you can imagine how, as the hours go on, turn into days, turn into weeks, the type of effect that this would have on somebody, and the lengths that your brain would go to try to keep you active, keep you entertained, keep you sane. In this particular case, it appears that those conditions did indeed wear on Mr. Allen, because within a few months, the defense had filed a motion indicating that his condition was deteriorating rapidly and asking for this order, this safekeeping order that committed him to the Indiana prison, that be modified. The state also filed some documents where it indicated likewise, seemingly fully conceding, yeah, Mr. Allen is losing his function. He's displaying psychotic symptoms. They reported he was eating his legal paperwork. But according to the state, these things, were probably because, over the course of multiple calls from this prison to his wife, they allege Mr. Allen then confessed to these crimes. So presumably this will be evidence that the state will attempt to use at trial to further inculpate Mr. Allen, to argue, well, he confessed during his incarceration. The defense sought for almost 2 years to get this modified. And it was only just recently, within the last couple of months, that was finally granted. He was transferred to a different local jail facility, got out of the prison setting. And ultimately, it was just a situation where, despite what seemed to be pretty obvious, that he's not convicted of any crime, entitled to a presumption of innocence, being held in one of the worst environments in prison, causing him to severely deteriorate mentally, that didn't warrant any kind of intervention from the judge for almost 2 years. She just deferred to essentially the claims of law enforcement as to why they thought these security precautions were necessary, and she prioritized that over the health and well-being of this presumed innocent man. The most high-profile, probably, instance of hostility to the defense was when Judge Gold disqualified the defense lawyers. So this has a little bit of background. Remember, there's a gag order in this case. And so what does that do for the incentives, for the reporters, the people that are trying to cover the story? They do shady stuff, right? We've seen it in Kohberger with false information being attributed to anonymous sources or obtained by exploiting certain vulnerable family members of the victims. In the case of Mr. Allen, what happened was this. One of the attorneys, the public defenders, was keeping the discovery for the case in his conference room. They're in the middle of depositions. There's a lot of prep to do, high volume of discovery. For me, this is routine when you're in a high work period like this. You got everything like spread out over your conference table, and you're going through it, referring back to it, and so forth. So basically had a war room type of situation set up. One of the attorney's friends, who is also apparently a former employee of this law office, went there one day, was able to get access into this conference room without permission, and also without permission, took photographs of some of the discovery, and then distributed that to podcast presenters. So that information was published. Crime scene photos, autopsy information, stuff that was not public and really not intended to be public, at least until the time of trial. This resulted in criminal charges against the individual who committed this act. Nevertheless, the judge's response to this was to blame the attorneys, blame the victims of a crime. She basically argued that they were negligent, grossly negligent, had failed to, ensure the confidentiality of the discovery materials, which were under a protective order. And so based on this conclusion, this sort of subjective interpretation of what had happened, Judge Gold decided that the attorneys were providing Mr. Allen with ineffective assistance, and she disqualified them from the case. She removed them from the case. The attorneys fought back. I personally give them a lot of credit for that. And the case ultimately went up to the Supreme Court of Indiana. I mentioned this briefly before, on a petition for an extraordinary writ. A writ of mandamus or a writ of prohibition, basically a direction from a higher authority. You need to tell this judge that she must do something or must not do something. The reason it's called an extraordinary writ is because you almost never get it. It has to be a situation where there's imminent harm, clear impropriety, and the intervention of the higher court is necessary. It's not going to be enough to just wait for the normal appeal process to be able to handle this. That writ was granted in this case, and the attorneys were reinstated. A little bit more of the background of this disqualification, I think, is necessary to illustrate part of the hostility. It's not enough just that she took an action that was so egregious that the Supreme Court of Indiana issued a writ to say you can't do that. First off, the timing was suspicious from my perspective. The defense had begun to seriously litigate this case, and in the course of seriously litigating the case, they had filed some extensive motions that were highlighting other investigative leads that they contended that the state had attempted to conceal when they were asking for search warrants, arrest warrants, and so forth against Mr. Allen. And that this investigation had revealed evidence of other suspects that were potentially a lot more consistent with what was known about the crime, the murders, the crime scene, etc., than any sort of theory involving Mr. Allen. Specifically, this is where if you've heard of this case, you may have heard of the Odinism angle. This got a little bit wild. Essentially, the defense had argued that the initial police investigation had identified the girls' postures, the way that their bodies had been arranged, and the placement of these branches on their bodies as being consistent with this pagan cult practice. I wasn't familiar with Odinism. Not that we don't have white supremacy in this part of the country, but just that particular flavor doesn't really seem to have landed in my neck of the woods. But this is, as the name indicates, it's a kind of inspired by Norse mythology and ideologies, and apparently does have, people that have studied it, people that identify it. It has a presence in the prison system, which is typically where you look for gangs. Gangs tend to emerge in prisons, spread out, once people get released and so forth. So these indicators of Odinism were identified by police early on in the case. This then was associated with certain people, certain other suspects who had some connections with the girls. So one of the suspects, Brad Holder, his son was dating one of the girls at the time. So there was a relationship there. Some other individuals that were associated with these people locally and associated with Odinism locally made some kind of disturbing suspicious types of statements about their potential involvement in the case. One of them, a man named Elvis Fields, had apparently been questioned by police, and at the conclusion of his interview, asked them, if my spit were found on one of the girls and I could explain it, would it be a problem for me? Yeah, not exactly the kind of statement that you would expect somebody to make unless they were very concerned that their spit might be found on one of the victims. So all of this information was unknown until the defense filed this filing and revealed in great detail these investigative steps, who the people are, the reasons for believing there were connections, and so forth. I will say that from a style standpoint, the brief can be a little histrionic. I hate to say it, but I'm just gonna say it the way I see it. It's a bit over the top. I don't personally think that the defense attorneys necessarily did Mr. Allen any big favors with how they chose to present it and argue it, because it reflected an attitude that was just very, very beyond critical of law enforcement, accusatory. It just kind of set a mood of snark. I'll just say it. It was a little unnecessarily snarky. But the bottom line was that the state took issue with how the defense had presented this. Judge Gohl herself had taken issue with how they presented it. They made unprofessional claims in the brief and so on and so forth, or the types of objections. So the timing of this was a bit suspicious, that these attorneys are actually fighting for Mr. Allen. They are putting information out into the public about the investigation and about the case that tends to undermine the state's case against Mr. Allen. And just on the heels of that, we're going to disqualify them. It's one of those things you can't prove, but circumstantially, it just doesn't really look very good. And the problem is that now, as we've gotten closer to trial, that hostility to the defense has continued to be reflected in some of the rulings about what's going to be allowed at trial. Because everything I just said about Odinism, other suspects, links, the ritualistic nature of this crime, so forth, yeah, Judge Gohl has excluded that from the trial. The state argued for them not to be allowed to present it, and that motion was granted. So unless something changes while we're sitting there in the courtroom, we're not going to hear any of that. So that leaves the defense in the position of only being able to challenge the state's evidence. And the problem is that Judge Gohl has hamstrung them there too, because she has limited their access to defense experts. The final reason why this case disturbs me so much that I'm going to spend 6 weeks of my life in rural Indiana to cover it is because, from what I have seen in this case file and what's been represented about what the evidence consists of, there is not a lot of good, strong evidence here to lead me to think that Mr. Allen is the one that did it. This is a little bit like the situation in Moscow as well, the Idaho 4 killings, where the circumstances themselves really make it hard to conceive how a single perpetrator did it. when you have multiple victims and, you know, these types of killings, you just it's hard to see how you could do that with one person, without, you know, having the other one restrained, without the other one screaming, being able to get away, being able to get to a cell phone, something along those lines. So the single suspect issue is quite hard to prove anyway, from my perspective. But reviewing the probable cause affidavit and the known evidence, this is just not a particularly strong case. So the bulk of the evidence against Mr. Allen is he was present on the trails, which he fully acknowledged and, you know, volunteered to police. According to police, he matches the description of the man on the video, the suspect. And according to police, he matches the description of somebody who was reported by a witness, according to them, to have been walking in the area where Mr. Allen would have been walking back to his car while being covered in blood and mud on their clothes. There is some dispute about whether this is what the witness actually said, that I'm sure is going to come out at trial. But for our purposes, this is what the state alleges. So he matches somebody who is seen covered with mud and blood. He's acknowledged to be there at the time. And so police then got a search warrant for Mr. Allen's home, where they recovered a .40 caliber Sig Sauer pistol. The pistol, the state is trying to link to an unspent, meaning unfired, bullet that was found at the scene, partially buried in the ground between the bodies of the two girls. When I say it was unfired, unspent, what this means is that there appear to be markings on the bullet, on the cartridge, that indicate it had been loaded into a magazine. From the magazine, it was chambered into the gun and then ejected from the chamber without being fired. So all of these steps, loading it into the magazine, from the magazine into the chamber, and then ejection from the chamber, these can all leave marks on the cartridge because of the different mechanisms involved in those actions. And so the state then is trying to prove that the markings on this particular bullet show that it can be matched to Mr. Allen's gun. That's pretty much the case. Oh, and then of course, you know, obviously the prison confessions, which are going to have a lot of issues of their own as well. So this gets my attention because ballistics is something I've litigated. This has been a legal challenge for decades now, where the state wants to be able to say we can look at marks on a bullet, on a shell casing, on a cartridge, or whatever, and we can match these to a specific firearm. And the problem is there is no scientific basis for being able to make that claim. There was a recent, very high-profile decision in the Supreme Court of Maryland back in 2023 that reviewed kind of the state of the science here now, you know, 15 years or so after this was first raised by people in high-profile positions that are concerned about pseudoscience in the courts. And so the Maryland Supreme Court looked at this and said, essentially, the state of the science is no. You cannot make a reliable claim that the markings on a bullet or on a casing or whatever can be matched to a specific firearm to the exclusion of all the other firearms in the world. You don't have the foundational knowledge that you would need to be able to make that claim. So the best thing that you can do is say, well, these are consistent with this particular firearm, but that doesn't mean it couldn't also be consistent with other hundreds, thousands, maybe even millions other firearms out there in circulation. So this issue is being litigated in the case right now as well, because the defense is trying to put on a defense expert to explain some of these limitations, and the state is trying to prevent them from being able to do that. At the time I'm making this video, we don't have a ruling on that yet, but it's just, you know, yet more indication of the efforts to chip away at Mr. Allen's ability to really be able to argue anything at all in support of his own innocence. If you take away that bullet casing and you discount the confessions that were made in prison, you really don't have anything. As far as we know, there doesn't seem to be DNA evidence. There doesn't seem to be location data. There doesn't seem to be evidence of any kind of a connection or any kind of motive that would give Mr. Allen a reason to commit these crimes. So yeah, I got real concerns about whether they've got the right guy here. And unfortunately, in most trials, the trial serves as the process to be able to vet that. If there are other people that have connections, that there is evidence that would tend to suggest it could be them, normally this is how you vet that. But it's not going to happen in this case. So that's just all the more reason why I am very deeply concerned that this trial process is actually going to meaningfully result in justice for these two murdered girls. To date, there was only a single occasion when Judge Gohl allowed cameras into the courtroom. This was the day that she disqualified the defense attorneys. What happened in that situation was that she called everybody into chambers, apparently read a statement that she had prepared that chastised the attorneys for being negligent, for, you know, not adequately representing Mr. Allen and so forth, justifying the order that she was making to disqualify them, and essentially told them that they could voluntarily withdraw or they would go out into open court and she would read that statement where the cameras were already ready and waiting to capture whatever she had to say. I bring that up because, again, I think it speaks volumes about not just the hostility towards the defense in this case, but also the desire for extreme control over the narrative, over what's put out in public, what they see, what they think about this case. Otherwise, Judge Gohl has excluded cameras. She is not allowing the audio recording that is kept for purposes of the appeal record. She's not allowing that to be released to the public. So it's just extraordinary what she is willing to present to the public to let them know and see for themselves versus what she is not. Jury selection is scheduled to start in this case on October the 14th. I am planning to be there for as much of the process as I possibly can. I don't know at this point to what extent there are going to be issues with that. Jury selection is conventionally open to the public. We're allowed to be there. We're allowed to watch it. So I expect that's going to be the case here, and I'm going to do my best to try to be able to observe it. There has been a courtroom order that's been issued. We're not going to be able to live tweet, to use electronics in the courtroom. So I'll be there with all of my yellow legal pads, dutifully taking my notes. Gonna be doing it old school style. That's okay. I'm old enough to remember how to do that. So that's the plan for the next 6 weeks, guys. And I just I just wanted to share with you as much as I could about why I'm so disturbed about this case, because it's just so alarming to go to such lengths to try to not allow it to play out in front of the public eye, to not allow the defense to defend itself. This is it's just an extraordinary situation that's very unfortunate to be surrounding this very serious and extremely tragic crime. So, Monday, my plan is to attend the court proceedings, and then hopefully every evening after we're done, go ahead and go live and just give you the background on what happened for that day. I'm going to be putting some content out on Substack as well. If you're not following me there, consider that, because that's where I will probably do a little bit more of a kind of deeper share of some of the case documents and some of the information that we have gotten about the case up to this point. And just to basically, as I'm able to develop my thoughts, reactions to what I'm seeing unfold, it's likely that I'll share a lot of that on Substack as well. So my hope is that this video has given you enough context to help you understand my interest in the case and why it's so important to be there in person. This is a case with high stakes. Justice for these two girls, for their families, closure is extremely important, but I have serious doubts about the ability of this legal process to be able to deliver that. I'm also deeply concerned about the prospect of a potential conviction sticking. One of the worst case scenarios in any criminal trial is going through the process only for it to be reversed on appeal and sent back to have to do it all over again. The rulings in this case, the record of the case so far has not given me a lot of confidence that they are going to be able to keep the trial clean. So I'm going to be on the lookout for possible issues that may come up in appeal, possible areas that may cause the trial to take a hard turn into error land. So this is why I need to be there, guys. It's essentially going to be the only way to have a legitimate, substantiated type of take on the case and on the trial process. Since we aren't going to be able to see it for ourselves remotely, I'm just going to have to go there and see it with my own eyes. So I do appreciate all of your support. Especially, I want to give a special shout out to everybody who paid to subscribe to support my Substack. The main reason I set up the Substack in the first place was to do this trip, to help me finance being able to fly out there, stay there for 6 weeks, rent a car, all that type of thing. So I really appreciate all of you who have stepped up to help me be able to do that. So my commitment to you in exchange for that is you're going to find me a reliable and consistent source of the information about what's going on in the courtroom in this case. Hope to be available for questions, share my my analysis, my thoughts with you, and so forth as it unfolds. So thank you all so much for joining me on this journey into a new case, one that I think is really important, and just for continuing to take an interest in justice in the world, in our legal system. Appreciate you joining me on this. So with that, I will plan to check in again after jury selection starts in Delphi next week. Thanks, guys, and I'll see you soon.